Do our wiretapping laws adequately protect the right to privacy? Communication surveillance constitute an important component in maintaining the sovereignty, integrity, and security of the state, and in aiding in the prevention and investigation of crime. However, there are reports of tools of mass surveillance being deployed by the government. This article argues for a mechanism which institutionally provides greater checks and does not provide untrammeled access to the state in our private lives. Introduction. The Justice Puttaswamy versus Union of India 2017 judgment has set the ball rolling for evolving a new privacy paradigm, strengthening the case of individual privacy protection and touching upon varied facets of the right, encompassing everything from the kitchen to the bedroom to the closet. One of the most common and well known state sanctioned intrusion into our privacy is the interception of our telephonic conversation. The telephonic interception is one of the oldest form of surveillance employed by the state. It is not surprised thus that the bulk of its regulation continues to stem from colonial law. Now that doubts regarding the nature and existence of the right to privacy have been put to rest, it is time for the government, members of Parliament, and various privacy law advocates to begin a comprehensive relook at the interception architecture in place. Privacy advocates indeed have a reason to celebrate. Apart from the recent historical nine-judge bench decisions recognizing the right to privacy as a fundamental right, it has also been 2 decades since another very historical decision, People's Union for Civil Liberties PUCL versus Union of India 1997, commonly known as the wiretap case. This judgment is significant because it was here that the court found that the powers of law enforcement agencies (LEAs) to intercept telephonic communications must be guided by duly established legal procedures, because interceptions involves an intrusion into an individual's freedom to exercise rights conferred under the Article 19 and 21 of the Constitution. The court laid down guidelines for how requests for authorization of interceptions are to be carried out, the period of interceptions, and so on. These guidelines were subsequently notified by the government. India's communication surveillance framework has several problems. First, there is a diverge between the various statutes that govern the interceptions framework of different communications, such as posters, telephone, and the internet, in the terms of the varying grounds that they provide to the state to intercept such communication. Harvanda. Second, the actual procedure governing the authorization of the interception calls for the closer examination, the efficacy of the present systematic safeguard against abuse in this regard is doubtful. Third, there is a paucity of data in the public domain pertaining to various facts of the interception architecture. Little information exists in the public domain as the extent of state surveillance over our communications is tying and with this problem of information asymmetry between the state and its citizen, and the fact that there are reports of the tool of the mass surveillance being deployed by the government. Prakash. The legality of such interceptions measures in the untested in the courts of law, which may find that they fall of the overarching constitutional standard for derogation of fundamental rights. This article examines certain aspects of second and third problem stated above. Rules of game, well intentioned but not practical. While the power to intercept telephonic communications comes from the Section 5 of the Telegraphic Act 1885, the procedure regulating how to competently LEA or to carry out this interception is governed by the Telegraph Rules 1951 under Rule 419A. The Union Home Secretary in the case of the central LEAs, or the Home Secretary of the state governments in the case of the state police, grant authorizations to such agencies to intercept telephonic conversation. The rules also provide for delegation to an officer of the rank of the Joint Secretary in unavoidable cases and exigent circumstances. However, the concerned LEA may itself, with the permission of its head or the Second highest ranking officer, not below the rank of the Inspector General, carry out emergency interception, but one must notify the Home Secretary within 3 days and also explain the circumstances. So, failing subsequent ratification by the Home Secretary within 7 days, this interception must cease immediately. The central agencies authorized to carry out telephonic interceptions include the Research and Analysis Wing (IB), Directorate of Revenue Intelligence, Central Bureau of Investigation, National Investigation Agency, Narcotic Control Bureau, Directorate of Information, Director of Signals Intelligence, and the Central Board of Direct Access. And additional similar powers have also been provided to the state police forces. SING. The rules also provide for review mechanisms. Under these rules, a review committee headed by the cabinet secretary in the case of the center and the chief secretary in the case of the states has been established. This committee is to receive a copy of every authorization of interception by the concerned home secretary within 7 days of him her doing so, and must meet at the least every 2 months to review the same. In case they find the regions wanting interceptions must cease with immediate effect. Prima facie, these rules appear comprehensive enough and padded with a sufficient safeguard, yet, based on the central government response to right to information requests annually, the Union Home Ministry approves close to 1 lakh requests for interceptions, while some estimates place the number of the between 7,500 to 9,000 requests per month. SFLC 2014. Even if we assume the lower number of 75 interception requests per month to be true, it would mean that the Home Secretary has to scrutinize about 250 requests for authorization per day. It is pertinent to note that whilst considering requests for interceptions by LEA, the Joint Secretary must mandatorily consider whether there are alternative means to acquire the right information sought. And if not, then the region requiring interception should be recorded in order to authorizing interception. The order must also specify with which officer is authorized to carry out the interceptions, to whom such officer may disclose detail revealed in the course of the interception, and so on. Clearly, the rules contemplate a near quasi-judicial application of mind and not merely a clerical process of blindly approving or rejecting such requests. It may be noted that the mandate of the Union Home Ministry includes matters relating to the border management, internal security, Jammu Kashmir affairs, census, official language, inter-state relations, union territories administration, human rights, police, prison management, and the freedom fighters prison pension (MHA) 2015. The Union Home Secretary thus is responsible for overall functioning of all these matters. One can only imagine how C can do justice to every application that infringes upon citizens' essential freedoms, given the quantum of interceptions request and the wide variety of the affairs of the Home Secretary must see to on daily basis. All of this does not even consider how many Home Secretaries in the past have had any legal training or technical competence to make such decisions. Home Secretaries at both the center and the state level are drawn from the Indian Administrative Service. Thus, a decision regarding a fit case of authorizing interception is not made by judicial officers or individuals with the experience in the law enforcement and intelligence gathering, but by a journalist bureaucrat. This has serious ramifications not just from the point of the view of individuals' right to privacy being violated, but also even from the point of the view of the state. Imagine a bureaucrat bereft of any legal, judicial, and technical training, afraid of being pulled for sanctioning too many authorizations for interceptions, who chooses to err on the side of the caution and rejects the majority of such applications and masses. Consider the mandate of the concerned LEAs. Such a decision of the Home Secretary authorizing or rejecting requests for interception would have implication on national security, terrorism related matters, smuggling of arms, fake Indian currency notes, and the possible also massive revenue losses for the exchequer. It is thus clear that the present model needs a major overhaul. Attempts that have been made to bring about the reforms. The Aforementioned PUCL judgment was the starting point of the such attempts. Recently, a bill touching upon this aspect was introduced in the parliament. It envisages a separate authority to deal specifically with such requests. It would be interesting to note the direction of the parliament debates over this bill in light of the recent Puttaswamy judgment. Given the fate of earlier bills of similar nature in the parliament, there is not much case of the optimism. Another model which may be considered is that of United States overseas pre-judicial intervention, wherein a judge authorizes a wiretap, much like how a judge could issue a warrant to make search and seizures or to arrest accused person solo. This model, while certainly more attractive from a human rights perspective, may be debatable in the Indian context, considering that the judiciary is already overburdened with the high rates of dependency combined with the huge vacancies. Gowda. It is pertinent to ask whether it is wise to have multiple judges assessing sensitive details of ongoing investigations versus having a single Home Secretary. There is also a question on whether the subordinate judiciary, if made part of this architecture, is competent to make such determination. It is clear that whichever model is ultimately chosen, be it an independent authority or privacy commissioner, as some suggest. Such Justice A.P. Saha, retired committee 2012. This authority should draw its staff from the judiciary, LEA, the intelligence community, and the civil society. In the interim, while different models are considered, at the very least, the Home Secretary may be provided a dedicated team of the joint secretaries having prior experience in the intelligence, investigation, and security. Data of robust privacy protection regime. Another concern in this respect is the leak of information that the government is willing to part with. On the RTI application to the Union Home Ministry seeking information on the agency-wise and month-wise breakup of numbers of requests for authorization of interception, the response stated that such information was not available, and even if it were, the information would be denied under the section of 8 of RTI Act. Interestingly, information had been provided to the applicant in the similar RTA request in the 2014 SFLC 2014. This RTA request felt very careful drafted so as to not seek information which would compromise India's security or any ongoing investigation. The intention was to simply discern how many such requests there have been in the past and what principles guide the Home Secretary's decision making process. Unfortunately, replies were not provided, and where they were vague. Without adequate data about the nature and the extent of the interceptions, reformed measures cannot adequately target current institutional flows. Any proposed oversight mechanism would only find itself still stifled, and the recent public discussion on the same would not be possible. The Delhi High Court's recent decision in the CPIO Intelligence Bureau versus Sanjeev Chaturvedi 2017 is significant because it brought intelligence agencies such as the IB into the fold of the RTI Act when the information sought pertains to allegations of the corruption of human right violation, considering and that the Supreme Court recognized the right to privacy as a fundamental right, and that this right figures in the several international human rights instruments such as Universal Declaration of Human Rights and the International Covenant on Civil and Political Rights. It could now be argued that data with respect to the interception, so long as not compromising national security, intelligence gathering, and the ongoing investigation, ought to be provided. The justification given by the Union Home Ministry therefore may no longer hold good, given the importance the judiciary has accorded to this uh, data, and this aspect is not only useful for academic pursuit but also for the realization of the citizens' fundamental human rights. Conclusion. A note of caution. This article recognizes that communication surveillance constitutes an important component in maintaining the sovereignty, integrity, and security of the state, and also is aiding in the prevention and investigation of the crime. It simply argues for the mechanism which institutionally provides greater Jackson does not provide untrammeled access to the state in our private lives. Such fears of abuse are not unfounded. Cases of illegal wiretaps have been reported in the press, discussed in the parliament, and even taken to court. Khaitan et al. 2010, Singh 2014. Similarly, access to information pertaining to our interception architecture is also understandably scarce. This paper does not argue for a regime of privacy where all data relating to interception is made publicly available. Rather, it argues for making data available in order to aid both policymakers and courts of law and understanding the limited overbroad state intrusions into citizens' private life without compromising on the pursuit behind the legitimate interception. Some argues that those who have nothing to hide need not be afraid of surveillance. This argument is flawed since it does not consider how pervasive surveillance influences human behavior, inducing what is termed as the chilling effect, making people alter their behavior due to their expectation of constantly being watched. Solo, 2007. This in turn affect the exercise of essential liberties such as the freedoms of speech, expression, and association. It can even be used as a tool to curb legitimate activities and to stifle dissent. Solo. Such concerns must never be allowed to persist in the country where the democratic ethos as strong as India's. While right to privacy has been termed by many as the most cherished right of individuals, it is enjoyment suffer from what is termed as the privacy paradox. Blank et al. 2014. This theory says that while an individual cares about her theoretical right to privacy, when it comes to the actual exercise of the right, and the right holders are willing to contractually alienate the right based on other considerations such as the peer pressure and the social norms. Despite this seemingly paradoxical situation, the widespread acceptance of the recent Supreme Court decision has shown that people do indeed value this right. Consensus largely exists that state-based institution into our private lives are not permissible, wherein in a few cases it is apt thus to make the most of this highlighted public awareness of our constitutional liberties and the freedom. These energies must be channeled to reform the existing state surveillance architecture as well.